The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning, Council, and to those who are watching us on our YouTube channel. At this time, I would ask Mr. Doug Shima, the Clerk of the Kansas Appellate Court, to please call our 11 a.m. docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Wednesday, October 27th, 2021 consists of one case. Appeal number 122680, State of Kansas versus Robert Glenn Terrell, Cowley County, briefs both sides. Your Honor, the appellee petitioner, State of Kansas, has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. I'm present and ready for argument.
May it please the court, Kristen Patty, counsel for appellant Robert Terrell, ready for argument.
Thank you, Counsel. Ms. Chalmers, you may begin your argument.
Robert Terrell committed the crime of aggravated escape from custody in 2018. He later dismissed his direct appeal and filed a motion to correct an illegal sentence challenging his 2004 Kansas Offender Registration Violation Act, or Act violation, sorry. Essentially, he wanted it scored as a non-person felony because that's the way it was scored in 2004. The district court applied this court's rule in State v. Keel and scored it as a person felony.
Can we start right there? How is Keel controlling in this case? It didn't deal with a pre-guideline conviction and how we were struggling with, and I think the legislature was too, how to categorize those crimes that weren't designated because it was pre-Kansas Guideline Act. And it dealt with that. It didn't deal with already designated crimes. So how is Keel controlling here? It might be somewhat analogous, but it's not controlling, is it?
I would agree that Keel does not deal with a post-1993 Kansas conviction, but Keel's rule was not limited to out-of-state priors or pre-1993 priors. It could be read to apply, and the state believes should be, read to apply to all convictions, because that is most aligned with what this court's discussion in Keel was regarding the purposes of the Kansas Sentencing Guideline Act, which is to allow similarly situated offenders to be treated similarly and to allow modern, essentially, views on punishment to be reflected so that a defendant is not forever frozen in time if the legislator decides it should later be a non-person.
Couldn't the legislature had reached the same conclusion that you're arguing for us to do now? Why isn't that a legislative prerogative versus something that we should extend in a case that we didn't really contemplate that's what it meant?
Certainly the legislator could act, and it did act in response to Murdoch and did what we consider the Murdoch fix on April 2nd of 2015, which did specifically deal with how to classify pre-1993 convictions and out-of-state convictions. But when this court was interpreting Keel, the court was interpreting statutory silence. It's just not immediately apparent to the state anyway why statutory silence would have a different rule for post-1993 convictions and then everything else, especially, again, with the rationale this court set forth in Keel regarding the purposes of the Kansas Sentencing Guidelines Act. The state believes that the Court of Appeals erred in 3 ways. 1, not applying Keel. 2, misunderstanding the meaning of the word repeal. And 3, applying the rule of lenity. Because the rule of lenity error is so egregious, the state doesn't plan on discussing that unless this court has any questions. Most troubling to the state is the misunderstanding of the meaning of the word repeal. Repeal cannot mean amend. If repeal means amend, Murdoch essentially comes back. So it is the state's position that repeal means what this court said it meant in Keel, which is when the statute no longer exists at all, or the state has been arguing when the elements of the crime themselves are substantively amended such that that crime has essentially been taken away.
Ms. Chalmers, how is it fair for a criminal defendant to enter into a plea agreement with the state with the knowledge that what they're pleading to is a non-person crime, and then have the legislature come along and make it a person crime and have the more severe consequences coming up?
Well, the legislator can always change classifications of crimes after a defendant commits the crime. The sentence that is set for the non-person felony at the time is the sentence they receive. But the court, the legislator could, there's no ex post facto violation, as long as when they commit the current crime, that rule applies. So here, the aggravated escape from custody, they commit the aggravated escape from custody and the legislator wants to deem all core offenses as person offenses, it can do so. But I think with this I understand this court's concern in this case, but you will be hurting defendants in other cases, or will be not, I don't know, be hurting, but the rule will not apply. Some defendants will not get benefits. So the state here, of course, gets the longer sentence, but in other cases, Cora is one, where a defendant could get a lesser sentence if the rule in Keel applies. Because the legislator, again, originally scored them as non-person, then scored them as person, and then now it's changed. So for those defendants that were in the time where it was a person, even if it was a drug offense, they will not get the benefit of the person versus non-person designation if we're forever frozen in time.
Why doesn't the order of the court freeze it in time? What we have here is a situation where at sentencing, the court would have made a finding that this was being sentenced in a non-person felony. That finding would have made its way into the journal entry. Why doesn't that become the law of the case?
Well, because the new crime is an entirely different case.
That is a new case, yes, but we've got a court order in the other case that said that becomes the criminal history that says this is a non-person felony. How can another judge or the legislature even change that court order?
Well, the legislator basically did that with regards to burglaries. There was about a year where burglaries were scored as non-person felonies, and the Court of Appeals has repeatedly said that they must be scored as person felonies because of the way that the burglary statute works, which the burglary sentencing statute, when they're classified, they're always scored as person felonies as long as they were under a certain subsection. So that's already happening, and the Court of Appeals has repeatedly held that, and we think that's right. The legislator absolutely can decide how to classify a prior conviction. I don't think there's any ex post facto violation unless we're trying to do that classification, or any other issue, unless we're trying to do that classification after the current crime is committed. So here, whatever the law for sentencing was when the defendant committed aggravated escape from custody, that's the rule that applies to him. If this court wants to say that post 1993 are different, the state isn't quite as concerned about that. I understand it'll be easier for PSI writers. It'll be a lot easier for PSI writers, but I don't think it complies with this court's understanding of what the purpose of the Kansas Sentencing Guideline Act was with Keel. Did I interrupt you, Justice Legal? I'm sorry.
No, I was trying to interrupt you. My question is, but it relates to what you're arguing, I think. Is there a difference between the person, non-person distinction as it relates to sentencing versus scoring? Is there a difference between whether a crime is person, non-person for sentencing versus scoring in a subsequent case?
Yes.
And does that distinction matter?
Yes, there is a difference. The sentence we can't legislatively or creatively fix. The sentence is set when the crime is committed. So the non-person versus person, it doesn't really actually matter at sentencing because that current score doesn't affect, at least currently, doesn't affect any kind of sentence at all. It does matter when it's then used later as classification, because that gives them the criminal history score and we all know that an A and B can be dramatically different from any other criminal history score.
But following on Justice Lukert's question, would it require the state to go, and I don't know how this would work or whether it's even possible, but to seek an amended journal entry or an amended ruling in the underlying criminal case?
It's certainly something that we have never done before. Frankly, the state for years has been arguing Keel applies. Because not just person versus non-persons changed, felonies versus misdemeanors. So right now, marijuana is sometimes more often a misdemeanor than it used to be. So if we're forever freezing what it was in time, all of those marijuana convictions are forever treated as felonies instead of misdemeanors. We've been, and I will personally take responsibility for this, arguing Keel is the rule since then, and have had quite a few defendants get benefits from our concession that Keel applies to non-person and person designations and felony versus misdemeanor designations, because the state just couldn't figure out why in Keel there would be a different rule that would be harsher for some Kansas defendants than would ever be for out-of-state defendants, or vice versa. We're no longer treating defendants similarly, which is one of the fundamental goals of the Kansas Sentencing Guidelines Act.
But once again, isn't that something the legislature could have addressed and didn't? And in fact, with statutes that were repealed, they said it is fixed in time at the time the crime was committed, as opposed to the current crime of conviction.
Well, if repeal means every time a statute is amended, then this court's decision in Keel is probably questionable, because the statutes were all amended in 1993 and they were amended in 2011.
I don't think anyone's arguing that interpretation.
I'm not arguing that,
Right.
but it's my concern for if repeal means amended. But yes, the legislator, if what you're saying is when there no longer exists, the legislator has had a specific designation that's
Yeah, they took that up. And the
Yes.
point is they've done that. So why can't they do it here and just give guidance?
I mean, that's essentially what the same thing this court asked in Murdoch. And then we had the Murdoch ruling, and the legislator did try and act, and this court overturned Murdoch ruling in Keel. So yes, the legislator could, if this court decides to go with the Court of Appeals and the legislator thinks that my argument is better, they could absolutely go in and fix it. And it is interesting that in 2015, there is legislative silence. So the legislator did act very swiftly to try and overrule Murdoch and attempted to do so retroactively. And they only did it for pre-1993 and then all out of state. So I can somewhat see the Court of Appeals' point. May I finish my thought, Your Honor?
You may, certainly.
The Court of Appeals' point, the legislator here was silent, but I also still don't understand how Keel's rule would have been different for post-1993 than all the others. This court was interpreting statutory silence at the time. And for that reason, the state believes State v. Keel is the better rule.
There are other questions? Thank you, Ms. Chalmers. Ms. Patty?
May it please the court. Robert Terrell committed the current crime of conviction on August 4th or 5th, 2018. And on that date, 216810 D2 specifically said, prior adult felony convictions for offenses that were committed before July 1st, 1993 shall be scored with the comparability analysis. What the state is asking this court to do is to override the legislature. Throughout its supplemental brief, it makes statements like, the Court of Appeals should have followed this court's decision in Keel. The statutory Murdoch fixes do nothing to undermine this court's ruling in Keel. Each of these additions mirrors Keel's rule, Admittedly, the Murdoch fix did not explicitly deal with post-KGA crimes, but there is no apparent reason to apply a unique rule to post-KGA crimes. Since Keel, the legislature has done nothing to indicate that it disagreed with Keel. After all, the statute expressly codifies the same rules set forth in Keel for all other prior convictions. Thus, any rule by this court altering Keel should only be applied to KSGA crimes committed on or after April 2nd, 2015. I think the state forgets the timing of all of this. It was Murdoch in 2014, the statutory amendments on April 2nd, 2015, and then Keel was released in late August 2015. While the statutory amendments maybe did or did not apply, and there were several dissents, Justice Files, you participated in one of them. Justice Ness wrote a longer one about whether those amendments should apply. When this court issued Keel, it knew which way the legislature was going. And on page 37 of that opinion, this court even said, we note that the classification rule we apply today is consistent with the recent amendments. This is not a perfect system. Yes, we are doing our best to treat similarly situated defendants with similarly criminal histories, give them similar sentences. There are going to be some times like this one when the state's going to feel like it got the short end of the stick. And there are going to be other times when maybe a crime is changed from person to non-person, when the defendant is going to feel like it's gotten the short end of the stick. As the state did say in its supplemental brief, applying the current legislative direction would be a lot simpler for PSI writers. Not only would it be simpler for PSI writers, it would be simpler for for prosecutors, for defense attorneys, district courts, the Court of Appeals, and this court. It's one less thing that we're arguing about. Otherwise, anytime, for example, the legislature decided to change how a crime was defined, we'd be back in trying to apply Wittrick to a prior conviction. And I don't know about you all, but every time that I have to get into one of these sentencing cases, it almost feels like I'm banging my head against the wall. Trying to wrap my head about how a statute from another case, another state may be this similar or different to a current Kansas statute.
What about the state's point? And I think we made the point in Keel that part of the function and purpose of the Kansas Sentencing Guideline Act is to not only treat people similarly, but also to keep current to allow some flexibility in the kind of current thinking on the peniological purposes of sentencing. And one of that would be is that you are forever stuck with a person, non-person designation. If we take your interpretation of where we should go here. And so if in 2005 or whenever this conviction was, it was considered let's say the offense was considered a person offense, but later the thinking is no, that really is not reflective of where we should be with that. It really is a non-person. There would be no benefit to anyone who would have been designated a person felony back earlier, if that makes sense. Really, there's no opportunity for any kind of amending of the thinking of how prior crimes should be considered. You're just stuck with that.
Actually, I disagree with that, because the district court can always do a dispositional or durational departure. And in fact, Mr. Terrell got one here. He's out.
That can be based on, you can base a durational departure or a disposition based upon the change in criminal history. Usually has to be a different kind of factor, doesn't it?
Well, I think something that a defense attorney could argue, that Yes, it was a person crime when he committed it, but the legislature has changed it to a non-person crime. And the district court judge could always take that in consideration in imposing sentence. And like I said, the Cowley County judge did here. We also have a unique circumstance, and Mr. Terrell was in the Winfield Correctional Facility because he violated his post-release by cutting off an ankle bracelet about 6 weeks before he committed this offense. So we have a Sedgwick County offense at the same time that was sentenced by that district court judge differently. That district court judge did leave it as a non-person, and the state did not argue in that appeal that his sentence was illegal. So we certainly, it's an issue that this court needs to resolve one way or the other. I think actually Ms. Chalmers and I, when this got set, or I think when she did her change of custody designation, certainly there's no published guidance on how we should treat something like this. So we do need guidance. But the legislature also has given us that guidance. It's restricted the comparability analysis regarding prior adult felony Kansas convictions to those prior to 1993. And if there are no other questions, I'll stand on the remainder of my brief.
I don't see any questions. Thank you, Ms. Patty. Ms. Chalmers, you reserve 3 minutes.
Yes, Your Honor. I would just like to briefly disagree with opposing counsel regarding the district court judge's ability to do a departure based on a rescoring by the legislator. If the criminal history is already taken into account, this court has made very clear that the district court has no authority to basically disagree with the law. In doing a departure, some other factor would have to apply. Other than that, I would waive any of my remaining rebuttal time unless this court has any further questions.
Seeing none, I would thank both counsel for your arguments this morning. We will take this appeal under advisement